Here in the United States, the president, it was determined yesterday, although he may appeal, is not immune.
Or he did, right?
He doesn't have total immunity. Yeah, I'm sure he did appeal.
I think they're going to hear it tomorrow.
The appeal is totally expected. In fact, we have a neat little chart showing how the appeal can affect the timing of this case. But yes, so here's the chart right here. So if Donald Trump appeals the decision yesterday, which rejects his claim that he's immune to these charges, that he subverted the 2020 election, he interfered with the 2020 election, he is going to go to trial on this criminal indictment that accuses him of trying to overturn the election results. So if you're looking at that chart, you see...
You're going to have to pause this video.
Yeah, you're going to have to pause the video. There are all of these different timeline scenarios. And remember, of course, that nobody needs to be reminded. This is all playing out in the middle of a presidential election cycle, one in which reports this morning, one from The Guardian says that the RNC wants Nikki Haley to drop out so they can completely consolidate behind Donald Trump. So the leading candidate for one of the major parties, one of the two major parties, is now caught up in this crazy timeline where you can end up going to the Supreme Court oral argument in the middle of March. You could just have, a grant of a stay without any limits. That could happen next week. You could have a grant of a stay with a 10-day limit. That could happen next week. Or you could treat the stay as a cert petition. That could also happen next week with oral arguments, again, happening in mid-March. So all of this is dependent on what happens within the next week. And then we can go down to the next element. As the timeline is so long, it didn't fit on one screen. That would put a SCOTUS decision somewhere in early April, with the trial beginning in July and concluding on October 5th. So all of these different scenarios, with the exception of one that ends in a petition for cert on May 12th, end in the fall. So you would have a SCOTUS decision around April, a trial beginning in July, and then the trial ending in mid-October, and then a trial beginning in June and concluding in September. So in 3 of the 4 scenarios, you have a trial concluding, based on the calendar, in early to mid-October, mid to late October, literally a week before the election, possibly, if it ends on October 30th in that time range, or in early September, right around Labor Day. So either way, the fall of a presidential election year, Ryan.
And tomorrow, the Supreme Court will hear oral arguments on a related question of whether or not the 14th Amendment, which says insurrectionists can't run for president, applies to Trump. And so the Supreme Court will be hearing that.
And this is before. Yeah, we can put that up on the screen because the two things, when you hear them together, are completely confusing.
But they're different cases.
Yeah, and SCOTUS blog calls this the biggest election case since its ruling, the Supreme Court's election ruling in Bush v. Gore. And again, it's whether or not he can basically be taken off the ballot because of his role on January 6th. And SCOTUS blog says, although the question comes to the court in a case from Colorado, the impact of the court's ruling could be much more far-reaching. Then they list that Maine Secretary of State ruled in December that Trump should be taken off the primary ballot there, and that challenges to Trump's eligibility are actually currently pending in 11 other states. So if we go back for a moment to the ruling in this other January 6th case, the charts of the Trump cases that some of the news outlets have done, by the way, are insane. Just to the tangle of different legal scenarios and all of the different things. It's just like absolutely crazy. Mike Johnson, House Speaker Mike Johnson, who had a very bad day yesterday, was caught by reporters walking through the Capitol complex and asked about the ruling. And here's what Mike Johnson had to say.
The Federal Appeals Court today just ruled that President Trump does not have immunity. Do you agree? Do you think that he deserves total immunity from anything that he's done in office?
I haven't seen that development. Was that this morning?
Yeah, they just ruled this morning.
I believe that they've been after President Trump for partisan political purposes. I think that's obvious, and we call it lawfare, and I think there's no other way to describe it.
That's what Mike Johnson had to say. Now, the ruling itself was 57 pages long. It was unanimous. It was a 3-judge ruling in the U.S. Court of Appeals for the D.C. Circuit. And as the New York Times says, it was unlikely to be the final word on his claims of executive immunity. Now, the ruling itself is actually really interesting. Did you get a chance to read any of it, Ryan?
Not the whole thing, no.
It's so long, but...
It was like, yes. I was like, this seems like a lot of words to say what seems pretty simple.
Yes, and so the Trump response was, if immunity is not granted to a president, every future president who leaves office will be immediately indicted by the opposing party. Without complete immunity, a president of the United States would not be able to properly function. And that's an interesting argument. It's an interesting argument because when you're reading this 57-page ruling, it's taking very seriously all of the Trump team's claims of immunity. And that's a particularly interesting one because it speaks to the nature of the system, that the system is getting a stress test in the Trump era of kind of hyper-partisanship. So what are the limits? You know, you have Ford pardoning Nixon. Would Nixon have had to go through this? Well, we don't know because Ford pardoned Nixon, and any idea of a pardon is basically laughable in this political context, whether it was Hillary Clinton or anyone else.
Well, DeSantis said he would have pardoned him, right?
Well, okay, so, but from the other party. Yeah. I guess Ford and Nixon is not the other party. But one of the key lines in the ruling, I thought, was, quote, "For the purpose of this criminal case, former President Trump has become Citizen Trump with all of the defenses of any other criminal defendant, but any executive immunity that may have protected him while he served as president no longer protects him against this prosecution. At bottom, former President Trump's stance would collapse our system of separated powers by placing the president beyond the reach of all three branches. Presidential immunity against federal indictment would mean that as to the president, the Congress could not legislate, the executive could not prosecute, and the judiciary could not review. We cannot accept that the office of the presidency places its former occupants above the law for all time thereafter." They also addressed one of the Trump team's arguments, which was about double jeopardy. They wrote, "Even if we assume that an impeachment trial is criminal under the double jeopardy clause, the crimes alleged in the indictment differ from the offense for which President Trump was impeached," because they're talking about the impeachment judgment clause, which in the ruling, quote, "states that the party convicted shall nevertheless be subject to criminal prosecution. The text says nothing about non-convicted officials. Former President Trump's reading rests on a logical fallacy, stating that if the president is convicted, he can be prosecuted does not necessarily mean that if the president is not convicted, he cannot be prosecuted." And as they're going through these 57 pages, these judges who, by the way, you had, I think it was, so Karen Henderson is an appointee of George H.W. Bush. And then you had two Biden appointees, Florence Pan and Michelle Childs, in this ruling. They're going through the founders' intentions when they were writing about impeachment and whether the founders intended it to protect somebody from these different prosecutions. And basically, they mounted some pretty persuasive evidence.
It's right there in the Constitution.
Yeah, 100%.
That they didn't. Did they mention the Navy SEAL argument that the Trump team made in the ruling?
I didn't see it in the ruling, but I could have skimmed over it.
During oral arguments, one of the judges asked, "Okay, well, what would happen if a president ordered Navy SEALs to go assassinate his political opponent?"
Oh, they did mention that. Yes, absolutely.
And the Trump attorney was like, "That would be fine. Like that would be a crime, but you can't prosecute it because of presidential immunity." And at that point, you're like, all right, I just know as a matter of fact
that's wrong.
That's wrong.
Yes.
That the president cannot put together a death squad that kills his political opponents and claim immunity for that. Like that's not a democracy. That's not a republic. That's not three different. You don't have three co-equal branches if one branch can assassinate all the 9 justices and then claim immunity for having done that, or can assassinate everyone in Congress and then claim immunity for having done that. That kind of gives one of the 3 branches a slightly unfair hand when it comes to negotiating with the others. And
it's funny because we're going to talk in the next segment about impeachment powers as it pertains to Mayorkas, but the system is really getting a stress test in these cases. And, you know, we may disagree on this. I don't think any of that takes away from the fact that this is lawfare. I mean, I agree with Mike Johnson on that point, that this is definitely just a concerted effort by a lot of, like, actually, you know, nonprofit kind of dark money groups on the left. It's not saying there aren't those on the right, but dark money groups on the left to make these ballot access challenges, and that, you know, the DOJ and the Biden administration have supported a lot of these efforts and put these efforts into the court. And you know, Trump's representatives have argued that this is disenfranchising voters. I also agree with that. I think, you know, you can have this conversation at the ballot box. I don't begrudge anyone for having these debates about the constitutionality of what Donald Trump did. Again, though, I don't think that makes this any less of lawfare, and I don't think that makes Tanya Chutkan, who's the judge that this now gets kicked back to, any less biased. I think she's completely, flagrantly demonstrated her biases in this case in a way that would be inappropriate in a lot of other cases, but is going to be allowed to stand in this case in all likelihood. So, Ryan, I think we've talked about this before. The individual cases are different. Some of them, even in the Trump orbit, are viewed as more serious than others. But there's definitely an effort to disqualify him rather than deal with him at the ballot box.
Yeah, that seems that certainly does seem to be what that strategy is there.
It's one way to do it.
Yeah, and if anyway, yes, the whole thing's getting wild because if you look at the timeline for some of these, you're talking potential verdicts in the late summer, fall. It's gonna be a bumpy ride.
Yeah.
From here on out, that's for sure.
Yeah, exactly. Like 2020 felt like a banana republic, and there's no escaping it. 2024 will feel like a banana republic, basically no matter what at this point. Hey, if you liked that video, don't forget to hit the like button and subscribe to Breaking Points.
If you want to see the rest of Counterpoints, go to breakingpoints.com to become a premium member and get the full uncut show every morning in your inbox and on Spotify.
Help us build independent news and get the full show every morning at breakingpoints.com.